Hello and welcome. Today we're going to talk about the Medicaid 5-year rule, something people get really confused about. My name is Richard Barid. I'm an estate planning attorney with Smith Barrett LLC and one half of the Estate Planning Guys. So the Medicaid 5-year look-back rule. Most people who come to talk to me about elder law type issues do have that question. They've heard about the 5-year rule. They've heard what it is. It does have to do with Medicaid eligibility. Let's back up for a second and talk about Medicaid versus Medicare, because I don't know who decided to name those two different programs so similarly, but it really does confuse people. So Medicare is primarily what people know it for is being the primary health insurer for everyone in the country 65 and older. Medicaid does many different things, but the program we're usually focused on for our clients is ABD, Aged, Blind, and Disabled Medicaid, which you can just think of as nursing home Medicaid, because that's usually what it is. So what is the 5-year rule and how does it relate? Well, you may have heard that there are some pretty stiff rules regarding how many assets, how much in the way of what they'll call countable resources a person can have in his or her name and still be eligible for that nursing home Medicaid help. You do want to get the nursing home Medicaid help if you can get yourself qualified reasonably. And the reason is it's really a very good benefit if you qualify. The way it works is if you need nursing home care, and that nursing home care is say $8,000 a month, which I think is even a little less average in the state of Georgia right now. Let's say you can afford with your Social Security to pay $2,000 a month of your care. That means the other $6,000 per month, every month for as long as you need it, potentially the rest of your life, the state will be paying for that deficit that you can't pay for to make sure you get the right sort of care. So it's a great benefit if you qualify for it. And one of the ways you have to qualify is you can't have more than $2,000 in what they'll call countable resources in your name. So when people learn that, and they're usually learning it in what we call a crisis situation, right? Where mom or dad has fallen, they're in rehab right now under Medicare payment, but the facility has told them within the next 20 days or the next 80 days that mom or dad is going to have to make a change. They can't just stay in rehab for that whole period of time beyond usually anywhere from 20 to 100 days. And then it becomes custodial care. Medicare won't pay for that. Medicaid does with that ABD program. The nursing home Medicaid program will pay for Medicaid type of help. But you can't have more than $2,000 in countable resources. There's a definition that's pretty detailed of countable resources in the Medicaid manual. But in general, we're talking about cash or cash equivalents. Having your home in your name will not make you ineligible for Medicaid unless you've got $600,000 or $700,000 in equity in your home, which most people don't. One car doesn't count against you. So there are things that don't count against you, but for all those savings that you've been putting away for so long, being so disciplined about, most of those would be subject to being countable resources, and Medicaid would want you to use those to pay your own way before they start paying. And one of the ways they do that is through the 5-year look-back rule. What the 5-year look-back rule means is that when a person applies for Medicaid, in that application, there's just a one-line question typically that says, in the last 60 months, 5 years, what assets have you transferred for less than fair market value? If you've transferred those assets to a spouse, that's called an exempt transfer. It won't be a problem. But what most people do is give it to their kids, right? Have their kids hold it for them because their kids are trustworthy, want to see that mom and dad get the best level of care that they can. And so we'll give it to the kids to hold. Well, the challenge is you do have to report that to Medicaid. And we don't have to get way into the weeds, but there is a way that they calculate what they'll call a penalty period if you have given away or transferred assets to most people, to non-exempt recipients during the 5 years immediately before you go into or need the nursing home level care when you make the Medicaid application. If you have, so let's do a quick example. Georgia says right now that the approximate average for a nursing home stay for a month in a semi-private room in the state of Georgia is $9,034. That's in 2023. It typically goes up every year or every couple of years. And so they take that figure, the average amount for a nursing home stay for 1 month, $9,034. They divide that into the value of what you've given away. So for the ease of our math here, let's say you gave away $90,000 in cash for your son or daughter to hold for you to get you eligible for Medicaid. And you did that only maybe 2 years before you needed Medicaid and had applied, well within that 5-year look back. What Medicaid would do, you have to report to them the value of what you've given away. They will take that average number, the $9,034. They will divide it into the value of what you've given away. So 90,000 divided by 9,000 is approximately 10. And that means for 10 months, Medicaid won't pay when they otherwise would. If you're otherwise Medicaid eligible, but you gave away that $90,000 within 5 years of needing the Medicaid assistance, Medicaid is going to not pay that extra $6,000, not pay whatever their part of the bill would be for the penalty period, which in this case would be 10 months in our example. They don't care how you pay. They assume what the family will do is bring those funds back that you've given to them to hold on to for you and just use those to pay through that 10-month penalty period. So it is important to pay attention to the 5-year look-back rule, and it's one of the other reasons that when you watch this video and others, estate planning attorneys will tell you plan ahead at least 5 years before you think you'll need the help. Now obviously you don't have a crystal ball, you don't know exactly when you'll need the help, but if you think things are going in that direction eventually, or you have some family medical history that tells you need to be concerned about an issue like that, get to a qualified estate planning attorney more than 5 years out. There are so many more options that way, and we can preserve so much more of the assets. In a best case situation, when someone applies during that, or needs to apply during that 5-year look back period and they've transferred assets, best case scenario, we can often preserve maybe half to 40 to 60% of those assets for most people, which is great. We're happy to be able to help. But if you come and talk to us more than 5 years out, there are more things we can do to preserve potentially all of the assets you've worked so hard to earn and to put away. So it's something worth thinking about before you just go applying for Medicaid or giving transfers, making transfers to kids or other people that you love and trust. We're not saying, obviously this is not legal advice, this is just information, so we're not saying there's never a situation where you give assets to the kids, but you need to think about it and be prepared ahead of time for what the ramifications are going to be of that transfer, especially if those ramifications are going to be, a 10-month or 20-month or more delay in your ability to get Medicaid to help you pay for that $8,000 or $9,000 a month Medicaid room that you might need. Thanks for spending time with me. I'm Richard Barid with Smith Barid LLC. If you want to find out how our team here can help you, click the button below to schedule a discovery call with our team. Do it today. We're happy to see you. Thank you.